This conference will now be recorded.
And Dan, if you want to go ahead and start the introduction.
Yep, absolutely. Again, thank you for welcome to tonight's fraternal benefits night virtually. So here we go. Again, I'm your field agent with the Knights of Columbus. I work for the Knights of Columbus. I am also the St. John Bosco Council rep for the past 2.5 years. I was also your original charter agent, and then Jim Bertine took over, and now Jim Bertine is retired, and I'm back. So, you know, it's like a bad heart attack. Anyway, I've been, you know, with the Knights of Columbus over 16.5 years. I've been in the industry for over 22 years, and I've always felt that people don't really care how much you know. They always want to know how much you care. So my goal for you is always, I want to maximize your savings. I want to maximize your protection. I don't want to upset your cash flow. And it's all about balance. I want to make sure things are being taken care of, but you're not having the like, oh my gosh, you know, food or insurance, yay. No, you don't have to worry about that. I want to give you, but the bigger thing is I want to give you a more value added services. One of those services is retirement, is planning for what happens to you when you become incapacitated, can't speak for yourself, or when you die. Question, what kind of control do you want beyond the grave? What situation do you want to leave your family in when you go? And where does your family go for extended care funding? You know, these are questions I get all the time. So I try to find solutions for you and your family. And in doing that, I wanted to provide you information to help you and your family take control of your situation. There are way too many life's unexpected events to guard against. But there is always one absolute truth. You can't take it with you. So the time you invest tonight will be a major family savings for tomorrow. We're gonna, you know, just ask the whoever's handling the executor for Michael Jackson's estate. You know, okay, talk about losing money. I want to introduce you to James Seidel and Sonia Rustisi.
Yep.
Is that it? Okay.
Yes.
I can murder it even more, but anyway, I'm sorry, Rustisi. I'm sorry. The Knights have been working with Jim's law office for over 20 years, and lots of relieved clients have completed their wills and trusts with Jim and Sonia. And so I want you to sit back, relax, and you know, listen to this, and hopefully you'll come away with a lot of new feelings. Hey, we got to do something. We got to take care of this. So with that, I'll get it off to Sonia and Jim.
All right. Well, thank you, Dan, for that wonderful introduction there. And I am so happy to be here tonight with you all to discuss something that I feel so passionate in, estate planning. And so we're here tonight with your field agent, Dan Garrigan, and he's going to be talking about why insurance products are so important to supplement your estate plan. We'll get into that a little bit later. I am here with attorney James Seidel, and he is going to help me go through our presentation with you tonight. A little bit about Mr. Seidel. He is a second-generation lawyer. He has been practicing law since 1980. He's been concentrating in the area of estate and business planning since the early 90s. He is licensed in Virginia, Maryland, and DC, and he's also a member of the National Network of Estate Planning Attorneys. What that means is that this National Network of Estate Planning is a group of lawyers, probably the best lawyers in the country, best estate plan lawyers in the country, that have bounded together for estate planning, to practice estate planning, and we're able to bring that wealth of knowledge to our clients, as well as we have a very sophisticated document production system to bring quality up-to-date, accurate documents to our clients. Jim Seidel is also a past Grand Knight, so he's very familiar with the Knights of Columbus products and how they are so useful to supplement your estate planning. So I have some information about myself. I've been in the area of estate planning, estates and trust for over 20 years. I've worked for several law firms in the Virginia, Maryland, and DC area. For about 7 years, all I did was help executors and administrators through the probate process. So I did that for about 12 years, so I'm intimately aware of the probate process in Maryland, DC, and Virginia. I also worked for a bank as a bank trust officer where the bank was a trustee. I received my JD from Concord Law School in 2013, and I am currently studying to take the Virginia bar.
So let me also add here that that if you've got any questions, we're going to take those at the end, verbal questions. But if you've got any, if you want to have an urgent need to ask a question, you can do it through the chat icon, and we'll either take it up at the end, or if I have some time, I might answer your chat on the side during the presentation. Sonia, take it away.
Okay, that's right. So if you have any questions, feel free to go ahead and type your questions into the chat box. And then after tonight's presentation, which should last for about 45 minutes, we're going to take about 15 to 20 minutes to answer your questions. We may also unmute you all so that you can actually vocalize your questions at that time. This is a diagram, a chart showing that 3 out of 4 Americans die without proper estate planning. So what is a proper plan? A proper plan would be a plan where you get to decide who's going to manage your assets and your money and you before you die as well as after you die. So proper planning is handling the before death and the after death. So here we go with this terrible statistic. Even famous people such as Michael Jackson that Dan had mentioned before died without proper planning because his estate was in the probate system. So I want to tell you that.
If I can get there. So also keep in mind that a lot of lawyers are out there geared towards the idea that you will not do proper estate planning. Your typical probate lawyer is based upon the fact that something has gone wrong, and that's where they make their money. We make our money by making sure things are helping you make sure they don't go wrong, and so you can save not only a bunch of legal fees and other financial fees, but reduce family conflict.
Well, that's exactly right, and so that's why I am passionate about estate planning, because I've seen the horrors that probate has upon a family and their assets. We have some handouts that are available for our attendees, introductory booklet, a copy of today's slides, an evaluation and sign-up form, and a 5% discount on services. If you would like to get this information, all you have to do is call our office. There's our telephone number there, or email our office, and a member of our staff will be happy to provide you with this information.
So what we'll do is, if you want any of those handouts, just let our office know. We'll probably just email you back with an attachment to an email with the attachment that you want.
That's right. So this is an example of our seminar evaluation form. So all you really need to do is fill this out and email it or mail it or email it to our staff, and particularly the email address. We like to communicate by email these days and make sure that that is clear on the form. So as I mentioned earlier, Dan Garrigan, your Knight of Columbus field agent, is with us tonight, and we'll be talking to you about the importance of insurance products to supplement your estate plan. The Knights of Columbus actually has a very, very nice personal planning workbook, and this workbook is a good tool, because if you fill out this workbook prior to meeting with Dan, and this workbook is going to give Dan enough information about you so he can hone in on the insurance products that are best suitable to you and your family. And there Dan is holding up an example or a copy of this workbook. So if you'd like to have this workbook, provides a lot of very good, valuable information in it, a place for you to document some important information to help Dan service you with insurance. Call his office or his cell or email him, and he'll be happy to give you this workbook.
I contacted the home office at one point, and they refused to give me the workbook. They said you had to go through your agent. So that's why Dan is here, among other reasons, tonight. So you can get a hold of that. It's really a good workbook.
Yeah, of course, exactly. I think I just went too far. So what is estate planning? Okay, estate planning is your ability to take care of all these things for you and your family and your assets without really the government having to do it for you. So we have number one, you want to control your property yourself, take care of yourself and your loved ones when you become disabled. And then two, you want to have someone manage your assets after you die, pass those assets to your loved ones the way that you want and when you want. And of course, you want to save every last tax dollar, court cost, professional fee possible. So that's exactly what estate planning is. It gives you the control to handle these things, name people to handle these things for you before you die and after you die. Because if you don't do that, the government then has to come in to handle it if you don't plan for that.
This definition was arrived at by the National Network. Sonia mentioned that earlier. I'm a member of the National Network. There's about 350 law firms that we bound together. We produce, the best documents in the country. We have our own limited liability company that I'm a member of and have contributed a lot of money to, and it's located in Indiana. But this is an example of some of the fine work they do. I think this really nails estate planning code.
Yeah, exactly. There are 4 types of estate plans: the unwritten plan, a written will plan, poor man's estate plan, and a living trust plan. And I guarantee you that every one of you tonight, it falls into one of these 4 plans, or you might be a hybrid of a couple of plans. So you're going to see here very quickly which one you fall into as we get into this. We're going to talk about the unwritten estate plan. The unwritten estate plan is exactly what it sounds like. It's unwritten. You have no documents in place. You have no documents in place that says who you want to manage your money, your life, your assets, your family when you become disabled. You have no documents in place for the management of your assets after you die. And when you don't have any documents in place, then the government has no choice but to come in and take care of that for you. So here we see that state law is going to determine all the decisions. It is the least favorable plan because it's the most burdensome. It's the most burdensome, and it is the most costly because you're completely at the mercy of the court system, and you always have to have a lawyer or lawyers involved. So there you see where the cost can skyrocket. So again, this is just, lots of people fall in this plan because they choose to, or they don't know better. Traditional will plan. The traditional will, everybody knows about the last will and testament, keeping in mind that the will only speaks at death. It's not even relevant until you die. So this is that after death planning. But a properly drafted will is very important because at least you're going to be able to name who the executor is, the person who's going to be managing all of your assets, paying all of your bills, and distributing your assets to your named beneficiaries. So you've taken that control out of the government. You also should have, your will should also waive as many costs as possible for the executor, okay? And so you should have it waiving the bond for the executor, so you don't have to, your estate doesn't have to pay that cost. Provide for an executor compensation. You get to decide who the beneficiaries are. Okay, so if you didn't have a will, you'd have to leave it up to whoever the state said was your beneficiary. So here you decide who the beneficiaries are. And again, you want to make sure that this will is properly drafted because you got to make sure you have contingent beneficiaries. Name someone as a backup. to a deceased beneficiary. Otherwise, if you don't have a contingent beneficiaries, then again, the government has to come in and decide who that beneficiary is going to be. So you can also decide how your beneficiaries inherit. Okay, you decide who the beneficiary is, how they inherit, and it may be that you want to set up a trust to protect that beneficiary's inheritance, not only from himself, but from his creditors, and that's where we see these testamentary trusts set up. The will is also the one document where you get the opportunity to say who you want to be taking care of your children or disabled children when you die. So you want to make sure you don't miss that when you're drafting your will if you have minor or disabled children. Otherwise, if you don't name your guardians in your will, again, it's going to be whoever the court decides to appoint as guardian. And really, you know, I've seen cases where it's the first relative that races down to the courthouse and the judge sees fit to appoint them as guardian. It may be someone that you really don't want around you or your children.
So the point that we hope we're making at this point is the first plan we talked about, the intestate, there's nothing in writing. You're completely at the mercy of the court system. Here with a traditional will plan, which is called the testate plan, which simply means you have a written will that's going to be accepted by the court. You get to lay all these 5 things out. You get to set the record as far as what you want. And without this, the court's going to make these decisions. And one of the most tragic situations are people who have not named guardians for their minor or disabled children, and they both pass away. And now we've got a court in a 10-minute proceeding appointing guardians that are going to affect your children's lives for the rest of their lives. And so if you've got guardians, if you've got minor or disabled children, please have a good will set up and have the guardians named for your minor disabled children.
That's
and
right.
if you have grandchildren, you know, you ought to be telling your children the same thing I just told you.
Yes, that's right. So as I said before, the will only speaks at death, so it's not even relevant until you die. So we have that after death planning document. So that covers the after death. So if we're going to prepare a will for you, we want to make sure that you do have before death documents in place. So this is where we have the financial power of attorney and the medical directive. So the financial power of attorney is the only document here which would, you get to decide who's going to be managing your money, your income, your assets for you when you become disabled. And there are 2 ways you can structure this document depending upon your situation. You can make it effective immediately, which would give your financial agent immediate authority over you, your income, your assets, or you can make it effective upon your mental incapacitation. Once your doctor deems you no longer have the mental faculties to control your estate, that's when the document would be effective. So depending upon your particular personal situation, you'll make that decision on when it'll be effective. The medical directive, also known as the medical power of attorney, here's where you get to decide who's going to make your medical decisions for you when you can no longer communicate to the doctor anymore yourself. This document also has a second purpose. The medical directive should include your end of life decision. So here you have an opportunity to say what you'd like to happen. For example, if 2 physicians certify in writing that you no longer have the certify in writing that your body is in a permanent medical state requiring extraordinary means of life support to be kept alive. You're at the end of your life and there's nothing to stop the dying process. So here there should be a provision embedded in your medical directive stating what you desire to happen if that occurs. This gives you the choice rather than putting that burden upon a loved one or, God forbid, the doctor deciding that decision.
Some of you might have followed one of the controversies during this pandemic was some of the hospitals were so crowded and they had people on ventilators that they were making unilateral decisions to withdraw ventilators from people so that they could presumably save other people's lives. The medical directive is the kind of document that no doctor would be legally permitted to withdraw a ventilator or something that's keeping you alive without your agent's concurrence, whether or not it be a spouse or a child. And that's one of the many reasons why we advocate medical directives. Incidentally, you can get a free directive at the hospital, but I can guarantee you it's not up to our standard with the medical directive that we do.
That's right. And I think that you want to be careful about the ones that are given to you by the hospital, because they're going to be slanted toward the hospital and give as much authority and control with their physicians as they possibly legally can. So, of course, obviously, it's best for your estate planning lawyer to draft this for you so it's customized toward what you want. If you are married, you're going to, each spouse will need each one of these documents. Each spouse will need the last will, the financial power of attorney, and the medical directive. We can now, with the advanced medical directive, which handles who you want to make your medical decisions when you can't communicate to the doctor anymore yourself, as well as the medical directive provides for your end of life decision. We can apply the Catholic teachings. Sometimes I call these the Catholic protections. We have 3 sentences here. You don't need to include all 3. You can pick and choose the one you want. The first one, that you desire your agent to follow the teachings and practices of the Catholic Church when making medical decisions for you, especially when it comes time to withholding life support. You want your agent to follow the tenets of the church. The second teaching or protection, you direct to be administered the sacrament of the sick when appropriate. And then finally, that you direct, or you would like to have the funeral to include the mass of the Christian burial. And that is language that we can add to your advanced medical directive. And it just puts in writing and tells your agent that you'd like for them to follow the Catholic Church teachings with regard to your health care. This is a nice diagram of a husband and wife will diagram. Now, in most cases, the husband and wife will mirror one another. What I mean by that is husband's will name wife as the primary beneficiary. Wife's will name husband the primary beneficiary. And then both of their wills will name their children or their other beneficiaries as a contingent to each other. Now, in most cases, not all cases, we do recommend that a husband and wife, if they choose to use wills to settle their estate when they die, to keep all their assets jointly with one another, or name each other as beneficiary on each other's assets. So when the first spouse dies, all those assets will flow automatically to the surviving spouse, and there's nothing to be probated under the first spouse's death. Because keeping in mind that wills have to go through the probate process. So you'd only want to have one will go through the probate process, because it's a probate process, it's burdensome, and there's a tax. There's going to be a tax on the assets going through probate. So if the case is, we advise spouses holding all their assets jointly, or making their spouse as beneficiary. Now, this is an interesting diagram put out by a fellow named Henry Apps III. He was a huge proponent of living trust, and this diagram is trying to show what the probate process is. So, even if you have a will, you do have a nicely drafted will to settle your estate when you die. That will has to be filed with the probate court upon your death, and your executor has to be appointed by the court to administer your estate. And the court is going to supervise the will process, supervise the executor through this process. And it's really difficult to determine at the onset whether it's going to be a difficult or complex process. We really don't know until we get into the process. Mr. Apps used to say that if you got sidetracked in one of these side boxes, that could delay it significantly. So you hear the horror stories about wills taking years, 5, 10 years, even longer to get through the process. Jim and I just finished a case where the will was in probate for 40 years. Okay, it was closed and reopened a couple of times, but as you can see that we never really know how long it's going to take. Now, when I practiced probate, I would try to get the probate to conclude within 2 years, because I knew that it was a terrible process for my clients, the beneficiaries. A lot of money is going to the lawyers to settle this. And so I try to get it done in 2 years, 2.5 years. But the thing about it is that the court is not going to let the executor make any distributions to the beneficiaries until the court is satisfied that all the decedent's debtors have been satisfied. So it's the Commissioner of Accounts really in Virginia doesn't like for the executor to make any distributions during that first year. It's really the second year where we see distributions being made. And also because of tax returns too, the court wants to make sure that the decedent's tax returns and tax obligations are satisfied. But you can see how the probate process could be very lengthy, and every single step through the process, it costs money. The executor has to keep paying filing fees throughout the process, so it is very expensive as well. The third type of estate planning that we see a lot of people try to use to avoid the government supervision into their lives before they die as well as after they die is the poor man's estate plan. We think this is a very, very poor way to plan. This is where a person will use a titling scheme to try to put authority and power into a loved one's hand, maybe, or to pass that asset to their loved one or their child upon their death. So, for example, if a woman wants her daughter, may put her daughter onto her account as a joint owner, thinking that that's going to give her daughter legal authority over her, which of course that's not true at all. That may give the daughter authority over that one account, but that doesn't give the daughter authority over her other assets or her income. So that's not going to be a good way to plan for a disability, obviously. So people will also name their children as beneficiaries on their assets, thinking, well, if they die, that asset will just go automatically to their beneficiary and escape the probate process. So while we see that sometimes that will work, in a lot of cases, I find that this type of a planning scheme kind of just drives my clients crazy, because they're constantly, running around trying to change their beneficiary designations to make sure all the children are going to be even-handed after their death. And many, many, many times it's not the case. Someone's always left out. Somebody didn't get, the same as another child. And so I've seen this type of planning really kind of rip families apart, because nobody really knows what's going on, and it's really hard to keep track of. And then you can never really avoid the probate process. So eventually that asset will be subject to probate, as well as there's no creditor protection here. So you really can't protect these assets from the creditors of your children. One big real problem here is that if you name your child as a joint owner of your bank account, or you put your child as the owner on your deed to your house, you're exposing that asset to their problems. So suddenly your asset is going to be mixed up with any problems that they have. If your child's going through a nasty divorce, if they're being sued, if they have a lot of debt, that asset that you just made them a joint owner of is going to be mired up in that. And so this is a very risky type of planning.
So tomorrow I'm finishing a Brother Knight's case. By the way, we're continuing to do business during this pandemic, just like we did before. Tomorrow's meeting will be by phone, and I just want to point out this is you can't see, but this is a lot of paperwork that the client has sent regarding the poor man's estate plan. They have everything under one of these categories right now, and tomorrow, since we're doing a living trust, we're going to make all of these various different schemes all coordinated through the living trust. So for example, I think this is a Jim Bertine, field agent, retired now, and this is one of his cases. And so they're bringing in the change of beneficiary forms for the Knights of Columbus insurance policies that they have, and we're going to make the beneficiary the living trust rather than their spouse and the children. And that way we're going to get just a tremendous advantage over this poor man's estate plan, which is what they have now.
Yeah. And that's exactly right. So the living trust is going to provide for the contingencies. If you have a deceased beneficiary, your trust provides for a backup beneficiary to inherit a deceased beneficiary share. So you're not going to be disinheriting grandchildren. You can have a grandchild of a deceased child receiving that deceased child's share, as well as we have the creditor protections. Because it's in trust, we can provide the creditor protections on your children's inheritance. I want to talk about the living trust plan. I will say that this is my favorite estate planning type. I'm very partial to the living trust plan because living trust plan is a private plan. Okay, it's unlike a will. A living trust is never filed with any government court body, so it's never becomes a public record. Nobody even needs to know any of your business at all. Living trust is going to be handled in the privacy of your trustee's home. We see here that 4 general advantages. The first 2 extremely important. The living trust provides for the before death planning and the after death planning, because your trust will name someone to manage those assets when you become very, very sick, disabled, and mentally incapacitated, no longer able to manage your estate. Your trust names someone to do that. And you've named a backup to that someone in case that first person is not available. As well as after you die, your trust will name a death trustee, synonymous to an executor, does everything an executor does, but the death trustee does this in the privacy of his own home, and he's not subject to court supervision. He doesn't have that burden. He doesn't have to file any reports with the court. So he handles it all in the privacy of his own home. He can pass your estate to your loved ones the way that you want to without any burden on your trustee, such as court supervision. Also, a trust is going to provide you with the greatest way to provide for your beneficiaries. Because if you do a trust under a will, a testamentary trust, which you can certainly do that, with a will, you always run a risk that the government, the court, will want to continue to manage that trust created under the will, and that is a burden for your trustee. And so if you have a very complex trust for your beneficiary, that's actually going to make it a little bit tougher for your trustee, because he's going to have the court supervising every step through that process. So because a living trust is never under the supervision of the court, you can greatly improve the way that you provide for your beneficiaries and their inheritance. Do you have anything to add on that, Jim?
No, except, well, one thing, one of the purposes of this slide is that some people think, well, living trusts are good for, the Rockefellers or, the Trumps and that kind of the wealthy people. But here is an example of all of these apply to everybody. Matter of fact, the argument can be made that the smaller your estate, the more you would want to, to do these things, because what you want to save what you possibly can. So this applies to everybody that's viewing this webinar right now. This applies to you, whether or not you're rich or poor, or complex or simple, or whatever the case might be.
Well, yeah, that's exactly right, because assets that go through the will, go through probate, have to be taxed or subject to the probate tax. And certainly if you have real property, which is extremely valuable asset, you certainly wouldn't want that to go through probate, because there is a probate tax. It is going to be a percentage on the value of the assets going through probate. So, the greater the value of assets, the higher that tax is. So living trust makes more sense. Our living trust package of documents are going to include the living trust agreement plus a financial power of attorney. You're going to still need a financial power of attorney because there are some assets that we can't put into a living trust because of the special, unique nature of the asset. For example, we can't make the living trust the owner of your Medicare card or your insurance policy. So when you become incapacitated, disabled, we still need some mechanism, some document to allow your family member to manage those types of assets, or payment of your bills, your credit card bill, your mortgage, things like that. Medical directive, so we still need that because this is the document that says who you want your medical agent to be, who's going to be making your medical decisions for you when you can't communicate to the doctor anymore yourself. We still need that. We have what we call a pour over will, and this is really just for insurance. If you fail to put an asset into your trust before you die, then that asset is going to be subject to the probate process, and so your pour over will be filed at that time to go after that rogue asset. Sometimes even in the best circumstances, I see an asset that failed to get into the trust. And so at least we've minimized the exposure of your assets to just that one asset. The pour over will name your trust as the beneficiary. So the court will, at the end of that process, order the executor to pay that asset to your trust. So it will eventually get into your trust. We also provide trust funding documents. Sometimes I call this the homework to my clients. So after they sign their trust, now we'll prepare the deeds to all their real property, their properties. We will also prepare special assignments for some assets such as businesses or royalties and patents, things like that. But we will give you a letter you can give to your bank to go to your bank and put your bank accounts into your trust. We will give you a letter you can give to your retirement plan company to make sure that the trust is designated as beneficiary or backup to spouse if you're married. But the point is, we are there for you. We're going to carry on with you and provide as much assistance as we can to make sure you get all your assets into the trust. Now, the living trust is, sometimes I like to call this or say that this is just a mirror image of you. The living trust is like your alter ego. It's just a vessel to hold your personal estate during your lifetime so that when these terrible things happen, when you become incapacitated, when you die, the living trust provides for the smooth management of your assets. So the living trust holds your personal estate. It doesn't change the way that you own, operate, or control those assets. There are three parties to a living trust: the grantor, the beneficiary, the trustee. Well, that is you. You are all of these things. While you are mentally competent, you're the trustee. While you are alive, you are the beneficiary. So when you do lose the ability to control the estate, then you've named a backup. That's that disability planning we've been talking about. Of course, when you eventually pass away, you have new beneficiaries. But while you are still alive, you are the only beneficiary, and if you're competent, you're the only controller of the assets. The trust holds your personal estate, so it's funded with the grantor's assets, and as such, we can't provide creditor protection while the grantor is still alive, because these are the grantor's assets. And so these assets can be taken by the grantor's legitimate creditors. That's why in the next couple of slides, we're going to talk about, what other types of things to protect your assets from creditors. Maybe using some subtrust if you're married. We're going to look at a screen for that, as well as using insurance products to help thwart the cost of those creditors while you're alive. Now, when you do eventually pass away, your document, again, will be distributed to your beneficiaries, just the same way as a will. This is an image of what you can expect to receive from our law firm if we do your documents for you. We will give you 2 sets of originals of your documents, 1 set of originals in this nice red binder, which I like to call the working copy, because there's a lot of really good information and tabs to keep track of information in there, like a list of your trust assets, your memorial instructions, things like that. And then you have another set of originals in this flat envelope. So we provide you with 2 sets of originals, then we caution that you put your documents in a safe place. Okay, so asset preservation within the living trust. Now, as I had said before, we're not going to be able to provide creditor protection on the assets of the living trust while the grantor is still alive, okay? But once the grantor passes away, we will be able to, the living trust will provide creditor protections to the beneficiaries, meaning that the beneficiaries' creditors will not be able to take the assets of the trust. Now, here we see an example of a married couple. So here we have first spouse has passed away, and surviving spouse is still living, but we see here that we've structured the trust so that the assets cannot be taken by the surviving spouse's creditors. So we can provide creditor protections on the assets once the first spouse dies.
The marital trust, I should point out, is a very popular trust because it is a pretty inexpensive add-on to the living trust. And as Sonia points out, it protects the decedent spouse, the first spouse to die, from the surviving spouse's problems. So for instance, husband dies, wife is sued, or wife goes into bankruptcy, or wife goes into a nursing home or has long-term care issues, or a wife gets married to a gold digger. We can protect the husband's, the decedent spouse's share of the estate or the children, we'll say, against the surviving spouse's legal problems during the surviving spouse's lifetime.
That's right. And then once both spouses have passed away, the estate will pass to the children, but with creditor protections. So the living trust is great for providing creditor protections on your estate when it's passed to your spouse and to your children. There are many different ways that you can protect your children's inheritance from not only your child, who may be a spendthrift and not responsible with money, but also from for little children. You know, if you have small, minor children, we certainly want to protect those assets until that child reaches a certain age where you feel they have the mental maturity to be able to control the asset themselves. Special needs trust, if you have a disabled child. Jim Seidel does have a disabled child, and so he's very, very familiar with trusts that will protect the assets from a disabled child's creditors. So depending upon what your situation is, we definitely want to implement some type of creditor protection on your estate for your beneficiaries after your death.
So these are the various different types of what we would call subtrust within the living trust. And so you got your master trust, so to speak, and then within those you have a marital trust and you have children's trust of various sorts. We pride ourselves in directing you to the trust that we feel is most appropriate for you. We'll explain why we think that's the case and why it's going to be a good thing for you to do.
That's right. Jim, why don't you continue to talk for a minute? I got to plug in my battery just for a quick second. Okay.
So again, one of the things that we do at the initial meeting when you first come to see us is we're going to help you set your goals and objectives. And this is going to be something that we're going to focus in on during our initial meeting. Do we need a marital trust? Do we need a trust for children? Typically, we are recommending some type of trust for a child. It'll fit one of these. I mean, if you're blessed with a well-adjusted, mature, happily married, financially sound children, and yes, there are a few children like that, then we're going to recommend a trust, because you never know what could go wrong. If something does go wrong, these sub-trusts protect the beneficiary from all the predators and creditors that are out there trying to get their inheritance away from them.
Yes, that's right. So even if you have children who are adult, healthy, responsible, we still think it's a good idea to put their inheritance in a trust. You know, you can make your child the trustee, make them the beneficiary. So while they still have control and access to it, their creditors can't take it. So if they happen to be going through a nasty divorce at the time they receive their inheritance, then their inheritance is still safe in mom and dad's trust, and those creditors can't take it. So there are lots of really good reasons to keep your child's inheritance in trust, even though your child is healthy and you're not worried about your child squandering it irresponsibly, but you're worried about what might be happening around your child, the people around your child. And here's a picture of Jim Seidel with his son Jimmy. And Jim, do you want to explain something about this picture? Where was this taken?
So Jimmy's severely autistic. He has a guardian that myself and his mom are his guardians. And so Jimmy will never be permitted to inherit property. So I have set up within my trust a sub-trust for Jimmy. It's called a special needs trust that will allow Jimmy to be qualified for life, for disabled children's benefits and so forth. And at the same time, we'll have a stash of money set aside for taking him on trips, or he loves Disney. So here's a Disney cruise that we went on. This actually is not a Disney cruise. This was taken in Dan Garrigan's backyard. He and his wife invited us over for the weekend, and that was a real nice boat you got back there, Dan. No, but the point being that this is the kind of thing when mom and dad are gone, and Jimmy might want to take a Disney trip, then the special needs trust will fund that, and of course more seriously could give him second opinions on medical diagnoses and that kind of thing throughout the remainder of his life.
Yeah. So extended care and catastrophic illness, who isn't worried about the skyrocketing medical care costs in this country and around the globe? There's only really so much that, we as estate planning lawyers can do to protect your estate from your creditors. And so that is why, you really don't really know what's going to be left in your estate by the time you die. Your estate may be completely exhausted or wiped out due to your expenses, your medical costs, or nursing home care. So that is why it's really important that you do have some other plans, involved with your estate plan, such as using insurance products. Life insurance that's going to help pay back the estate if it's wiped out by all of these costs. The life insurance that is going to be there so that there's going to be something that's going to be left to take care of your spouse, your children, and your loved ones. Because none of us really know what's going to happen to our estate, before we die. We just don't know. And so it's really good to get those life insurance policies as part of your estate plan, and you need to get them sooner rather than later. Not sure what's making that sound. So here in this diagram, we can see that a life insurance trust can provide some greater creditor protection. I apologize for this. I really don't know what that sounded. I thought I had muted everybody, but we'll see. So there's a echo. Sorry about that. Not sure what to do here.
Well, you don't have your cell phone on, do you?
No, I don't. Mute everybody for now. Let me go back into here.
I think you got everyone.
Okay. Dan, are you still there?
Yes.
Jim Seidel, are you still there?
He's muted.
Oh.
Gotcha.
Jim Seidel, are you there?
Yep, I'm here.
Okay. All right. I'm sorry about that. I apologize. Hopefully we'll do this. So here's a diagram where we have a life insurance trust, which which is a separate trust in addition to your living trust. you could utilize a different trust that would be the owner of the life insurance policy, and the trust would also be the beneficiary. So this is a way to provide some additional protection on the policies and the proceeds of those policies from your creditors. Jim, do you have anything to elaborate on this? And I do want to bring Dan into the discussion here, for you to talk about how life insurance policies would help save the estate and protect and be useful for the children and the beneficiaries.
Yeah, real quick, Sonia, you want to mute everybody, okay? Try doing a mute all because you've got at least 5 people are unmuted right now.
Okay.
Anyway, while she's doing that, the real quick thing is, remember, it's an inevitable return, okay? So if you're going to be, you always know that something is going to happen in the future. And how are you going to replace what's going to be lost? Here's a quick way of doing it. Most of us don't have a stockpile of gold bullion in a Swiss bank account. So the question is, how are you going to be able to pay for extended care? Using long-term care insurance is a great benefit. Can it be used for in all situations? Yeah. Could it be lost if you never use it? Yeah. But what you're looking at is buying peace of mind. You want to make sure that your family is protected one way or the other. Whatever's going to happen, you've got coverage. And then, of course, using permanent cash value life insurance can also be a part of your, you can use that as part of your extended care. Tapping into that, especially if you find out that you have chronic illness or something that's going to be taking you sooner, you can always tap into a death benefit of the policy. So there's lots of uses of the product. We're not going to get into all that, but there's a lot a lot of resources for you that you've got at your fingertips that we can definitely help you and your families make sure that you guys are covered. So
yeah,
and for those who don't do this, you're going to be faced with some very difficult decisions, one of which is we can convert your living trust, if you have a living trust, to an irrevocable trust. And after 5 years, we can protect the estate from possibly nursing home expenses. But it's a very painful process, and you really want to avoid it at all costs. But that is one of the advantages of a living trust. I did this for my own mother, where she was in a nursing home, Catholic nursing home, for several years, and we had not gotten her, I wish we had, long-term care insurance. So we had to pay for about 3 years. In those days, it was a 3-year wait. Now it's 5 years. And we paid for 3 years in nursing home. In the meantime, we transferred her living trust to an irrevocable trust, and we were able to secure, we saved the home and another couple $100,000 for the children when she passed on.
Yeah. And so, yeah, so that is one thing that, clients can do is impoverish themselves, make themselves poor, give all of their assets away so that there are no assets that could be taken by the nursing home or medical creditors. But again, that's an extreme approach. I don't have very many clients who want to give up control of all of their assets. And, you have to time it okay, because there's a 5-year look back period on those gifts. So if you give all your assets away today, that gift is not going to be complete for 5 years. So, that's why, I'm thinking about insurance as a way to refund the estate, if you will. If your estate is completely exhausted by these types of creditors, or maybe, move some of your money over to an insurance policy before, so that you can move that money out of your estate, so that now you have an asset that will be there to go to your children when you pass away, and it's not gonna, those premium dollars weren't used to pay for your debt while you are still alive. So there's other different types of things that you can do within your estate planning, your financial plan, to make you healthier, if you will, if these costs hit your estate. So do you have anything to add there, Dan? Uh-oh.
He's
Oh,
muted.
you're good. Good.
Sorry, I didn't mean to, somehow you,
No, it's me.
oh, you're muting. Okay, gotcha.
Sorry.
So, also, we have a lot of clients who are active military. So we pride ourselves in preparing documents that are suitable for our active duty military. For example, we can prepare multi-jurisdictional documents because obviously, you know, a person in the military doesn't really know what state they're going to be a resident of for sure when they end up passing away. So it's really important to make sure that their documents do have the proper provisions that's going to protect their estate from death taxes, notwithstanding which state they're going to end up in. Because as we know, the states still have their death taxes. We all are subject to the federal tax, but some states still have a death tax. Jim, do you want to elaborate on the planning we do for active duty military?
Well, so a couple of weeks ago, I got a call from an active duty military member that we had done their living trust a few years ago. And by the way, I'm a former JAG. JAG should not be doing living trust. It's really, nor should, by the way, most general practitioners. But we did a living trust for him, and because we knew he was active duty, he was assigned to the Pentagon. Him and his wife were living in Virginia. So rather than making them Virginia documents, since we knew he was going to get reassigned in short order, we did a multi-jurisdictional document that allowed the trust to go from state to state until, and simply said that wherever he passed on would be the state of final residence. And so he called me a couple of weeks ago and he said, well, we're in fact getting reassigned to a Maryland installation. And he wanted to know, do we have to redo the documents to Maryland? Typically, the answer would be yes, at the tune of, oh, I don't know, $1,500. But I said, no, we have a multi-jurisdictional document and it'll follow you to Maryland. In addition to that, he had another child since we had done the living trust. And our living trusts always have afterborn or adopted children or grandchildren. So I always like to get the new child in the documents. But in this case, I said, you know, you can save yourself, you know, a few $100s by doing this down the road, since it's automatically built in to the document. So there's an example of what we've done for an active duty military man, a family.
Yeah, thank you, Jim. Thank you for that. Businesses and estate planning. So we do a lot of business planning. Businesses are an asset, and they are, you know, an asset is part of somebody's estate. So if we have a client that has a business, you know, we're going to be talking to that client about protecting their personal estate from the creditors of that business. Because if you're in a business, you're at a higher likelihood of being sued because you're regularly out there transacting business with the public. So Jim, do you want to talk about our business planning?
Yeah, I would urge anybody who's undertaking any kind of business, regardless of how small or insignificant it might be. I mean, if you're just having people over and selling Tupperware, even that presents all sorts of opportunities for lawsuits. Someone gets hurt in the meantime, or they stumble on your sidewalk or something like that. And so we urge people with businesses to incorporate their businesses. And even if you don't incorporate, but if you do incorporate, then we're going to urge you to have a living trust, because otherwise your business is going to be subject to conservatorships and probate. And that's a very, very cumbersome process. A few years ago, I got appointed by a farmer's son. Both the farmers, the parents had died without any estate planning in place. And we had to process that business through probate by court order, and extremely time consuming, 300 to 400 hours. We cut them a lot of breaks, but even then the final fee comes to about $45,000. Had the business been incorporated and had they had a living trust, we would have saved all of that in the legal fees that eventually had to be paid by court order.
Yeah, so So, incorporating your business is going to wrap that, layer of protection around the business and keep those creditors away from your personal estate. That's very important. As well as you want to use a living trust as your primary estate plan document, because you'll want to assign the business to the living trust so that when you're disabled and can no longer manage the business, your trustee will be able to continue the management of that business for you while you're sick and disabled. And then when you pass on, your trustee will be able to settle that business in the privacy of his own home and never have to go through court process. So, Jim, you're absolutely right. Living trust is appropriate when you have businesses. So our process is, the office, it does provide a 2-hour introductory estate planning meeting with you to review your current estate plan and talk about your objectives. This 2-hour meeting, by the way, is completely free of charge, no obligation to you. And here you'll have an opportunity to sit down with one of our lawyers, one of our paralegals, and then we will address your situation, your issues. We'll talk about options that are personal for your family. And then we will quote you a flat fee. So at that very first meeting, we will tell you what our fee would be to put an estate plan that's most suitable, best suitable for you and your family. We just charge flat fees. That's how we fee structure everything. Sometimes we do hourly rates. If you want us to help you with your mom's probate, we do charge hourly rate for probate, because you never know what we're going to get when we go through the courthouse. But there is no charge for the introductory meeting. If you are interested in seeing one of our paralegals or attorneys for that 2 free-hour meeting with us, all you have to do is contact our office. We have our phone number here. We have our email address. You can also ask for a copy of today's slides, the evaluation sign-up form, as well as an introductory booklet and your 5% discount certificate on fees. We encourage you to reach out to your field agent, Daniel Garrigan. Yeah, I pronounced that right, Dan? Daniel Garrigan. We do encourage you to reach out to Dan to get a copy of the Knights of Columbus work book, and start filling out that booklet and meet with him so that he can help you decide what insurance products best fit your needs and goals for your family. He's showing the booklet right now if you have the capability of visualizing this seminar or webinar. There we go. So here's his contact information. He's got his telephone number and his email address. So I highly encourage you to reach out to him. The estate planning process. Oops, sorry about that. Well, so there was this university, Northwestern University, that said if you merely did 5 to 6 hours of estate planning, it's going to save you hundreds of thousands of dollars. So this is really quite an alarming statistic here. So, but yeah, I could see that you're going to be able to save hundreds of thousands of dollars just by putting these plan documents in place, because you see, you're going to have your family members doing these things for you and avoid the court costs and the lawyers.
We have a 50-yard line seat on seeing this happen. I mean, it may seem extraordinary that we're saving that much money, but it's amazing what we can do to help you avoid expenses down the road. It's just, it really is something to behold. So these figures don't necessarily surprise me.
Yeah, I know for a fact probate lawyers, they make a lot of money off of probate. And some of those lawyers right now, I know a DC lawyer, his hourly rate is like $800 an hour. So that's a lot per hour, and it really adds up fast. Our process, we offer that initial meeting. It's a 2-hour introductory meeting. There's no fee or obligation. And there we will come up with a plan that's proper for you and your family. Now, if you decide to proceed, we will schedule what we call a planning meeting. I call this planning meeting decision day. That's the day you come to the meeting. You have to have your decisions. Who's going to be your guardians? Who's going to be your trustees? Who's going to be your medical agent? Things like that. That's another 2-hour meeting. And then the signing meeting is 2 hours. So you can see here, you're getting a lot of face-to-face time with our staff because we are passionate about what we do, and we are concerned about you, and we want to make sure that your plan is exactly the way that you want it to be. So we see here your signing meeting is when we actually bring your documents to you. We go over everything with you. You sign everything. And if you're doing a living trust, we're going to give you what I call the homework for you to get the rest of your assets into your trust. Of course, we'll do the deeds to your properties. We'll do special assignments for your special assets, such as businesses. But we will give you a letter that you can give to your bank, and a letter you can give to your retirement plan company, your life insurance company. So we're going to help you as much as we can. And then about 90 days, 60, 90 days after you sign your trust document, we're going to call you on the telephone and see if you've done the homework that we've given to you, and make sure that your red binder is all intact and ready for you to have your meeting with your family members. I do encourage my clients to have annual meetings with their families to go over their estate plans with their families. We have a nice summary inside the binder that they can give to their families as well. Now, we recommend that every 3 years you have your estate planning documents reviewed. That's just our recommendation. It's not required, obviously, but at this meeting, we'll make sure that we'll refresh your memory as to what your plan is. Maybe you've forgotten that who you've named as your guardians or your trustee. Maybe you want to make some changes. So we'll refresh your memory as to what your plan consists of. A lot of times my clients will bring their children to this meeting so their children can hear firsthand what the plan is. And then we will if you're using a living trust, we'll want to go through the assets of the trust and make sure all your assets are still in trust the way that they should be. There is a picture of our law firm receptionist. Her name is Linda, and when you call our office to request any documentation or request for a meeting, Linda will be the one that will be scheduling. Linda handles our calendar and schedules all of our meetings for us, so she's very pleasant, very sweet. You'll really like her a lot. So I guess if you're interested in more of our webinars, then you can always call our office or go to our Facebook or our website. We're going to try to post our upcoming webinars, dates and times. I know that Jim Seidel and I talked earlier today about possibly having another webinar maybe in June, but we will keep those future webinar dates and times on our Facebook and our website.
I think, Dan, we've got maybe one set up in 19 May.
That is correct, with council, with the Holy Spirit Council, yeah.
So my guess is the access to that webinar will be the same as today's access code. So for those of you who'd like to be a groupie and go to another seminar, you're welcome to do that, or webinar, I mean.
So I'd like to open up the floor now to just questions from the attendees. I think at this point in time, I will unmute everyone, or try to anyway. Oops. Well, I'm not sure if I know how to do this.
You might have to do it individually.
Oh, I do it individually? Okay.
Hi, good evening. I have a question for Dan, or from all of you guys. If I want to make an appointment with you guys to speak about my living will, the whole package thing, do I need to wait to get the booklet from Dan, or either talk to him first, or what I have in terms of life insurance?
No, you don't have to wait. We can go over that information, and I'll ask you the questions. You don't have to have it all filled out. We can go over some of hit the highlights that you're looking at, hit, what's really important for you right now. We go over that, and then as conversation moves on, yeah, we can get start working on the book and get you more information. So,
Okay.
yeah,
That's good. I'll give you a call then.
look forward to it.
Thank you.
I hope everybody can hear me now and hear us. Do we have any other questions?
Yeah, hello? Can you
Yes,
hear me?
hello, go ahead. Yes.
Yeah, I tried to get on. I mean, I listened to your audio, but I couldn't get onto the webinar itself. I tried on my phone and the computer. And I don't know what happened. I even took off the blockers, but for some reason I couldn't get on. Is there a way that I can get the presentation?
Yes, we are recording it. So it's going after we're going to save it to it'll be saved to our website and our Facebook. Isn't that correct, Jim?
Yes,
This
and
recording?
we've got a YouTube location where this will be saved to.
So to
Okay,
answer
and
your
then-
question, yeah, go ahead.
Well, I mean, how would I find it? Is it say if it's on YouTube, is it Seidel Law Offices webinar with a date, or how would it be titled?
Well, we just developed it. We've got 2 video recordings on that site. I know I believe, Sonia, you've got one.
What is the
The
website?
best way to answer that question would be to call our office and to get the actual information on how to do that from the secretary.
Yeah. Jim, I believe we're
Yeah,
going
because I don't have any of the information. I don't have the phone number because all I had was the phone call because I couldn't get on. I don't even know what your phone
So you
number
want
is.
to give them the phone number, or should I give them the phone number?
Well, yes, and our phone number for those who are listening who weren't able to see this visually, the phone number is 434-964-0366. And if you call that number, then Linda, the receptionist, she will give you a copy of the slides of tonight's presentation, as well as she'll be able to tell you where this webinar is going to be saved at. I believe our tech gentleman who handles our technology in our office is going to be saving this webinar to either our Facebook or our website, maybe to YouTube as well, but it's going to be saved on one or all of those places. And we will know in the next couple of days so that you can access it and watch the whole thing.
And to answer the other question that somebody had, his website is www.jamesseidellaw.com.
Yeah, www.jamesseidellaw.com. Thank you, Dan, for that.
Okay, thank you.
Our pleasure. Do we have any other questions from the attendees?
I have a question. Does a will expire, or is your latest one the one that's still valid? Or you have to look at it to figure out if it has an expiration date?
You want me to take that?
Jim, why don't you take that one?
Yeah, no, there's no expiration on your will. Your will is a permanent document. And I mean, you could do a will when you're 21 years old and die when you're 70, and that will is still going to be in effect. As you know, we recommend you have it reviewed once every 3 years, because I can assure you an older will is going to have changes to it. For one thing, the statutory citations have changed. So you want to do that. One thing I do want to point out, though, is the power of attorney is a different story. And for those of you who don't have a living trust, you're totally dependent upon a financial power of attorney to carry you through periods of disability. And some banks won't accept powers of attorney that are like 2 years old. Now, it's not right for them to do that, but they can do that. And so your power of attorney, it can be a problem. I know when I was a JAG also, we had a termination date on powers of attorney, but you would never do that I've never seen a will with a termination date on it. So I hope that answers your question. But again, if you've got an old will, please come on in, have us take a look at it, because I can guarantee you we're going to find some things that need to be changed.
And a trust supersedes a will, correct?
No.
Oh, will supersedes a
Well,
trust?
okay, I see what you're asking for. Yeah, any asset that's in a trust bypasses the will. That's absolutely right. I think that's probably what you meant to say.
Yeah, okay.
But you will typically, with a living trust plan, still have a will, as Sonia indicated, called a pour over will, that will take any asset that's not in the trust that has to go through probate and will pour it into the will. Let me give you, for example, and just to tell you how expensive probate can be. I've had to probate 2 motor vehicles. That was the only thing we had to probate, was a motor vehicle in each probate case. And the fees were in the $3,000 range just to probate the motor vehicle. Everything else was in the trust. And so, that's an example of this cost savings you have with the living trust. You can imagine if it costs you $3,000 to probate a vehicle, how much is it going to cost if you have a $100,000 or $200,000 estate?
Yeah.
And
I have a question.
I have a follow-up question to your point about the banks refusing to honor 2-year-old power of attorney.
Uh-huh.
How often do they expect you to change it then?
Well, I listened to, I forget where it was, just recently, where I think it was a bar journal, where they talked about banks having a standard policy of if the financial power of attorney is more than 2 years old, they just won't accept it. They can also not accept it for other reasons. They might say, well, it doesn't give you enough power to open or close bank accounts. It might, because the power of attorney is only valid to the extent of the written words on the 4 corners of the document. And so if there's something that doesn't address opening and closing bank accounts, the bank may say, too bad for you. I'm trying to make a case here for 2 things. 1, make sure your documents are reviewed periodically. And 2, this is an example of where a living trust is going to be better, because your living trust also doesn't have a termination date unless you put one in, which I can't imagine why you would do that.
Mhm.
I hope that answered the question.
Yeah, so for
Yes,
all the
thank
assets
you.
that are in the living trust, see the trust, since the trust is the owner of an asset, that gives the trustee the authority to manage that asset. But there are some assets that we can't put into a trust, and if all you're relying upon is the financial power of attorney for the management of your assets when you become disabled, if all of your assets are going to be managed under that financial power of attorney, then you do run a risk that a bank or financial institution, for fear of liability, will say, no, I'm not going to take that document. The document doesn't, give you the authority to do what you're asking, Mr. Financial Attorney, or attorney, in fact. And so that's why the living trust provides the best disability protection, because you don't have to worry about that when the asset is in the living trust. You see, when you create that living trust, you tell the bank that you have a trust. You tell the bank to make the trust the owner of that bank account. And you tell the bank that when you become disabled, you tell them this person's going to be walking in, your disability trustee. And so the bank has a greater level of comfort knowing that they're going to be protected, and they're protected against liability. Right, Jim Seidel?
Yeah, I want to add, just so you don't get information contrary in other places. Technically, in Virginia, your power of attorney is supposed to be respected by third parties. But heck, there's a loophole a mile wide in that law, and I just pointed out one, and that's that your bank could say, the power of attorney is not good enough. Our power of attorney, by the way, I think is like 19 pages long. It kind of turns people off, but I'll tell you, when you are dealing with a third party, also selling real estate. I mean, if your spouse is disabled and your spouse is on the deed to your house, and now you want to sell the house and your spouse can't do it because he or she is disabled, you got a problem on your hands if the real estate agency or the title company won't accept the power of attorney. Now you're into conservatorships trying to get a court order. And suddenly, what was going to cost you maybe $500 is now costing you $10,000. So,
So do we have any more questions?
keep them coming.
No, but thank you. You guys did an awesome job.
I have one question that's a follow-up to that real estate question.
Okay.
So is it better or just the answer is it depends, which is the easy answer, but to have both? If you have a living trust or your spouse is going to, get everything, is it better to have two names on a title of your home or just one?
You want me to take that?
Assuming you have a choice and you're like refining or something like that.
Well, okay, I'll take it, Sonia. So if you've got a living trust, you want all of your real estate to be titled to that living trust. Now, there's going to be an exception if that real estate is a business property like rental property, then we might put it into a limited liability company. But we want all of your real estate. So we don't want either spouse's name to be on that deed. We want the living trust to be the owner of that property, with, of course, you being the trustee. So you have complete power to buy, sell, mortgage, open, close, do whatever you want with that property. But that would be the answer. Now, if you do not have a living trust, then you're into either passing the living trust, the real estate through probate. And by the way, there's going to be a probate fee on that cost. Or you're going to send this by way of the poor man's will. You're going to have a typical husband and wife would have property held as tenants by the entirety. The problem with that is with the problem with many poor man will plans, is that when the second spouse dies, then we're back to the probate problem again. So you're only kicking the can down the road as far as staving off the problem we have with that real estate. Let me also say, if you have real estate in multiple states, let's say you have a property here in Virginia and you have a beach house in North Carolina, now you're facing two probates. You're facing a Virginia probate and a North Carolina probate. If on the other hand, you have a Virginia living trust, we can title the North Carolina property into the living trust and void double the probate. And that alone will probably be saving you 3 times what our fees are for doing this document in the first place.
I only wish I had that problem.
Well, hang in there.
Yeah, there you go. Thank you.
Yeah, you could also, I don't know if people can see the chat thing, but you can also, yeah, okay, so I got a chat question. Can you give examples of assets that cannot be put into the trust? Well, there are certain assets that you're not going to put in the trust, such as debt. You're not going to put your credit card debt into the trust. You're not going to put mortgage debts in the trust. If you're married and you have, let's say with Dan Garrigan, you have an IRA, you typically, IRAs cannot be owned by the trust, and we would typically have the spouse named first, so we can do a spousal rollover, and then we'll name the trust as a secondary recipient of the IRA. That would be another example. I'm trying to think, sometimes with motor vehicles, because the DMV is such a difficult organization to deal with, we actually do advise sometimes clients not to put their vehicles into the trust. That would be another example. Sonia, any other things you can think of that you might not want?
Yeah. Well, and as I said before, earlier on in the presentation, that's why even though you have a living trust and you've got, all your assets, your bank accounts, your real property, your cars, and your businesses, you still need the financial power of attorney, because there are some assets, I said, that you can't put into the trust because of the special unique nature of the asset, like your Medicare card, your health insurance card, your Capital One credit card, your utility bill. The ability to pick up the phone, the financial power of attorney, attorney in fact will need to call the Social Security about you when you're incapacitated. He'll need to call the IRS about you on your tax status. So these are all types of assets that you can't put into a trust.
So Anthony did a follow-on question. Does an IRA then have to go through probate? So let me kind of go through what I said before. So let's say you're a married couple and you have an IRA. If you've named the surviving spouse as a beneficiary, that avoids probate, okay? And then when you have the trust named as the secondary beneficiary, let's say your spouse has predeceased you or you're a single person, then trust by naming the trust as the beneficiary, you're avoiding probate that time. So you're avoiding probate. What you're not going to do is if you have a standard will, a traditional will, and you name let's say you name your children as
in case somebody sent the code around, other people, the first 60 people can log in.
all right, we're being infiltrated here. So I hope that answers your question, Anthony. He said thanks on the chat, so I guess so.
That's good. That's good. Yeah, but most all types of assets you can put into a trust. You know, any type of asset you can think of, you know, except for those intrinsic, special, unique assets like, you know, your Medicare card or your bills and your debts.
Tony, you just did one, a South Dakota brand, livestock brand.
We did a cattle brand. Yep.
And those cattle brands have their own ownership. And so we assigned, this was a Virginia client, I think, we assigned their South Dakota cattle brand to their living trust. So if they die, we don't have to probate because you own that brand. We don't have to probate it through South Dakota.
Yeah.
That was kind of an unusual one. And we just recently, divorce proceedings, we put this person was afraid they might die before their divorce is concluded. And so we put all the proceeds from the divorce going to, in this case, the woman, in the event that she died. So you can do a lot of new things.
Yeah, with the assignments, you can assign most all kinds of assets to your trust. So, well, if there's no more questions from the attendees, I'm going to throw it off to Dan Garrigan to speak for a few minutes, and then we'll go ahead and conclude this webinar.
Beth Morton, she had a quick question.
Yeah, what about a vacation club contract? Can they be placed in living trust? Yeah, absolutely. So we do timeshares. We've done timeshares throughout the United States. We have a company that we subcontract. We call USDs. They're really a fantastic company, charge very reasonable rates, we think. And if you do not have but if you have a timeshare that doesn't have a deed to it, such as a vacation club, then we can assign the vacation club to the living trust. Now, if the vacation club is located in a non-US jurisdiction, you know, we might not be able to guarantee you that it's going to work in every case, but we can put you in the best position possible so you don't have to probate that through a foreign jurisdiction. You know, if you have a vacation club, say, you know, in France or something like that. So I hope that Beth, that answers your question on that. But by the way, absolutely do that, because if you don't do that, your vacation club contract is going to go through probate, and it's going to be hell. It's going to be hell to pay, because you're going to have to convince the judge and the commissioner of accounts that your transfer satisfies their requirements. And good luck on that. You're welcome, Beth.
So want to thank everybody for coming tonight. This is a very successful virtual seminar, and so really happy that we were able to, you know, at least reach a lot of people in these troubling times. But during these troubling times, you can really see more of the value of what's going on, what you can do to make sure that your families are protected. Father McGivney gave us a blessing over almost 140 years ago, basically allowing the Knights in our program to be protected. If you're not in the Knights, and we will find protection for you. Okay, you know, it doesn't have to be within the Knights, can be another company or something, but we will help you. Other than that, again, I want to thank Sonia and Jim. You guys did great, and as you can see, there's tons of information, there's tons of experience here, all to help you. That's it.
So Dan, I got another question. Should I take it, or you want to move on?
No, it's okay. Go for it.
So Anthony, does the Soldier and Sailors Relief Act protect assets in the trust? The military member is the trust holder. Yeah, I remember back from the JAG, all the Soldier and Sailors Relief Act scenarios. What the trust is going to do is it's going to allow you to control that asset when you're disabled or you're deceased, and will be able to get the same relief. I would certainly think the same relief. I haven't researched it, as the Soldier and Sailors Civil Relief Act would give you if you didn't have a trust. So the trust is going to help you. And the worst thing, it's not going to put you in a worse position. So I would say, a qualified yes to that question.
All right. Well, again, please reach out to us. We've got lots of resources to help you, and we look forward to hearing from you soon. Again, want to thank everybody, and we're constantly keep everybody in your prayers. Keep safe, of course, and we'll be here for you when you need us. That's basically it.
Thanks, Dan.
Thank you.
Thanks again. You guys did a great job.
I appreciate that.